Welcome to Sparkcast, the podcast by entrepreneurs for entrepreneurs, where the conversation is raw, the lessons important, and the stories inspirational. Are you ready? Let's go.
Hey everyone, welcome to the Sparkcast podcast. I'm Nicole Smith, today's host, and I'm joined with two special guests, Dan Bordenave, CEO of Bisep Inc., as well as Lorelei Graham, a partner, lawyer, patent agent, and trademark agent from Norton, Fulbright, Canada. Now, before we get started, I want to thank our partners, the Intellectual Property Institute of Canada, for making this special episode possible, especially in light of World IP Day, which is this month. So let's welcome our guests to the show, beginning with Dan Bordenave. Thanks so much for joining us today. Why don't you tell us a little bit about yourself and about your company, Bisep?
Yeah, thank you, Nicole. Thanks for having me on here. It's an honor to be on here with you and Lorelei as well. So Bisep is a medical device company I started a few years ago, in which we invented a medical device that attaches a patient's wheelchair to a patient's walker for the purposes of their transferring and mobility training. In regards to patents, we have filed and have our patents issued in North America. And as utility patent, which we'll learn a little bit more later. But yeah, I'm happy to be here, and I'm happy actually to learn more about the entire patent ecosphere with Lorelei leading the way. Thank you.
Fantastic. Well, thank you so much, Dan. We look forward to learning more about your company and about your journey with the whole patent process. Next, we have you, Lorelei. I look forward to learning more a little bit about yourself. So why don't you give us a little bit about your background and yeah.
Great. Thanks so much, Nicole. And it's always a pleasure to help anybody out in the patent sphere. So I'm a partner at Norton Fulbright. I'm also a patent agent. Been practicing over 25 years, so I've been doing this for a little bit of time. IP is obviously a passion of mine. It's a great area to practice in, but it's also really positive because you're usually protecting and helping people advance their dreams and things that really mean a lot to them. So it's a really positive area of the law, and I'm looking for today's chat.
Fantastic. And I love how you position that, how, you're helping people, achieve their dreams. I don't think people look at IP as part of achieving their dreams. I think they look at it more as, part of the painful process. But I love that positive spin. So thank you so much for that. So today we're going to be, of course, spending some time talking about patents and why they're so important and, the process of getting that. So why don't we just get started right with the most basic question, and that's what exactly is a patent, Lorelei?
Sure. So a patent is a negative right. It gives you a monopoly to basically exclude people from doing whatever it is that you are trying to protect. So whatever your invention is about, you're really, really stopping others from doing it. So what that means is it's a negative right. So you could have a patent and commercialize and sell that invention, or you can stop other people from doing it. So we always think of patenting as being both a sword and a shield. And that's an interesting thing about it, because sometimes clients are commercializing certain aspects of their business and they want to patent those and protect those. But then there are other aspects of their business where they just maybe want to keep the monopoly to themselves, and they may not commercialize it, but they want to stop other people from getting into their area of practice or selling, basically.
Okay, so and how long does a patent usually last?
So a utility patent lasts from the date of filing for 20 years till it actually lapses or expires. In most jurisdictions, you have to pay maintenance fees, so you maintain the patent yearly. That's a cost that you need to consider when you're putting your budget together. Not every country has that, so it all depends where you go, because patents are jurisdictional. But it's a decent length of time. And the other part that people have to remember is when the patent expires, it then is basically technology that's given out to the public, the general public. So anybody can practice that invention. And that's important when you're looking at your business and what to protect and what not to protect. Because you might want to consider a trade secret and keeping things confidential if it's something that you don't want to have out there in the world and you feel it has longevity or legs to last longer than 20 years.
Okay, fantastic. Dan, have you got anything? Because you've gone through the journey of having to, acquire a patent. So,
Yeah.
any insight?
Yeah, no. I mean, definitely, we filed a utility patent of attaching a patient's wheelchair to a walker, so a device that does that. Now, Lorelei, is one stronger than the other compared to utility or design patent? And if you had the chance, which would you go for first?
Well, I think that's a really good question. First of all, as you've noted, there's different types of patents, and some people might have heard the term design patent, which is the same thing as an industrial design. It really is protecting different things. So a patent, utility patent, is really about how something functions. So how your wheelchair extension device sits onto a walker, right? That's really how that all those different, sort of elements work and function together. A design patent really is protecting the look and feel. So what that means is you can protect, for instance, the shape of a chair, right? It's somebody's designed a beautiful new chair. You're going to protect how it looks. It still functions the same as a traditional chair, but you're actually protecting the look of it. Sometimes certain subject matter actually falls into both categories. A good example, you might have heard this term, is an article of manufacture, where basically there isn't really any moving parts or how things function or work differently. Like if you think about, a mechanism that takes the chair up and down, but the form actually provides some sort of function. So sometimes you can have actually both types of protection available. And when you're working with your patent lawyer or patent agent, you should talk about that. What are your options available? Could it be a trade secret? Should it be a patent, utility patent? Should it be a design patent? A design patent or industrial design lasts 15 years. So it actually gives you some decent longevity as well for protection and monopoly. But it all really depends on what you're trying to do.
Perfect. And just a follow up on that. So, I mean, you hear about just lasting 20 years. At that point, is there can you pay for extension, or does it become just public knowledge and everybody has a crack at it?
It's public knowledge. There are instances, especially in the pharmaceutical area, where there are certain inventions which take a really long time to get to market, especially with drug approvals and what have you, where you can get extensions for those kinds of subject matter. But traditional patents lapse after 20 years from the date of filing. What's really important is to think about next generation. So what does your next generation device look like? How have you made improvements? Are those improvements still, does it make sense to patent them, or are they just, small improvements that really don't meet the patent criteria? And the patent criteria is something that people need to think about. You have to have utility, as I'm sure you found out, and most inventions are useful, but it has to be novel, and that no one is doing something identical to what you're doing, and it has to be inventive. It has to have something that's the spark of invention that's really going down a different lane or a different path. And sometimes you'll hear the terms, it can't be obvious to somebody skilled in the art, and that's other terminology you may have heard. And if it is, then you won't get a patent, but you have to meet those 3 criteria to get it.
Okay, and I guess the strength in having a patent would be the monopoly of it, right? So I think of some brands that monopolize their product, that you just call it that. For example, Tupperware. Tupperware probably held on to a patent for so long that now you refer to any type of reusable container as Tupperware, or a Ziploc bag. They're sandwich bags, but for so long they've held the brand because I guess they've held the patent in that space. And then after 20 years, it became public knowledge, right?
Yes and no, because you're sort of bleeding into trademarks, and where those brands are super strong, things like Tupperware and Ziploc, or Kleenex is another really famous brand that sort of went generic. It's not necessarily because they had patented technology, it's because their brand is so powerful that the consumer who's using their consumers, because there would have been billions of them using them every day for numerous years, that brand has become so synonymous for what the actual product is.
Okay.
So of powerful marketing is what that is.
Exactly.
So, can you ever have them? Sorry, Nicole. Go on. I can talk forever.
That's okay. That's what we're here to do.
No, that's okay. Because I was just going to say, because Dan, you've actually gone through the process of having to file for a patent go through the meeting with the lawyer, go through that whole thing, and you're even ramping up to a whole new level in that world, because now you're looking at it needing to patent for internationally. So as a business owner, as an entrepreneur who's gone through this, I'd love to hear your perspective and your experience on the whole process of having to file it, and just how that feels from your perspective. Because I can ask Lorelei, but she's going to give us all the technical stuff. I want to know the journey that you have had to go through and how that feels like, because our listeners are entrepreneurs just like you, and they want to understand the feel of it. So you go for it there, Dan.
Well, it all depends. Do you want the good, or you want the good, bad, and the ugly? Because there are some instances.
Because you know what? We are here to educate our listeners, and they need to get the full Monty.
So the great thing is that, I mean, the firms that I was using at the start, I've been through a couple of different firms. So a couple of the first firm was really great. Met with their lawyer. He did an extensive patent search, which I think is absolutely necessary. It does cost a little bit of money in addition to filing, but it really saves you a lot of money too. And if you get a good and honest firm and lawyer, then they're going to say, well, this device is patentable, or perhaps I wouldn't waste my time, because I'm sure Lorelei can agree there's some things that you shouldn't just patent. You should just try to bring to market and just try to make your best of it, right? So it was great. Like I said, it was a lot of research that the lawyer was doing, and just back and forth, but very, very professional. And then when we filed the patent, and getting that patent pending email and all those documents sent to you, it's quite empowering as an entrepreneur, because you feel safe, right? You feel safe that, my idea now, I can share it with people. I could perhaps start to commercialize because I have some sort of protection, right? I don't feel like I'm going to get ripped off anytime soon, right? So it's a great feeling, because it really puts everything to a side, and you can really focus on other aspects of your business. And then basically you're meeting every so often, making a couple of amendments to it. So the process that I went through is that we submitted all pictures to our lawyer. He got it professionally drawn up with all the appropriate vocabulary, sent off to the patent agency, and then it's a pretty long waiting game. Both patent agencies get probably thousands, if not hundreds of thousands of patents every single year, and to review it takes some time. So I think for the US, we've waited, it's about a year till we heard back, and then we had to make a couple of amendments to it. And then it was another 6 months after that, which we got the final issuement, which is actually really, really quick in the patent world. And the only bad thing about it was when we were using our first firm, the patent agency responded to the firm, and they didn't see the email. So I followed up with them a couple months later, and it basically went into some sort of pergola, if you will, or some sort of limbo, if you will, in which it was almost public knowledge, released public knowledge, and I had to get on my lawyers and act really, really quick, and they responded to them, and then after, that's when I decided to change firms. But yeah, it really scared me, because I forget what it went into, and then Laura, you can help me, but basically it's because we didn't respond in a certain time frame that they asked us to. It went into like something where it was going to become public knowledge. So
abandonment.
Yes, abandonment. Yes. Which totally freaked me out. I'm like, what the heck do you mean? I thought you guys were taking care of it. And they're like, yeah. And it was, you know what it was? It was like right when the first lockdown, I think, was about to start, right? So it was just like everything was going crazy. And yeah, it was very, very scary. But it was all taken care of, and it was all fixed. And now it's still standing strong. So, and again, the other thing is you got to realize you got to plan for the expenses. Obviously, patents aren't something that's they're affordable if you plan for it, but they're definitely necessary. But again, it's not like you're going to make a decision overnight about buying a patent, because it does cost quite a bit of money. So it's something that you have to plan towards, and you have to be disciplined to save enough money to make sure you do it, because the protection you get from it is, it's great to really start your business so you can focus on other things.
Fantastic. Wow. So how long was the whole journey from the minute you
I think 2 years. 2 years and a bit, 2.5, which I don't know if that's quick or not. And Laura, you can go on that.
That's super quick. That is super quick.
Yeah, and actually, here I have the proof right here. You actually get a beautiful little booklet sent to you by the mail with all your drawings on it and everything, right? So you can see the drawings on it. But yeah, it's really, really cool. And I have this like in a frame. Nobody can touch that. It's the most expensive piece of paper I've ever gotten, right? Next to the degrees.
I was going to say more expensive than your master's degree. And
Yeah, we'll see. Depends who you use.
oh wow, that's impressive. So then, Lorelei, you said 2 years was quick. So what then typically is the length of time?
Oh, wow. I hate to use this typical lawyer phrase, but it does depend. If you're talking about the United States, which is where most companies go first, it's because it's usually the largest market for most entities. It really depends on the subject matter of your patent, because in the US and in most jurisdictions, there are sets of examiners who are skilled people who understand the art area that your patent, the subject matter that your patent is about. So as a result of that, you're getting somebody on the other side of the table who understands your invention. But if it just so happens there's lots of people ahead of you, they're examined according to when they come in. So there's a queue. And you can jump the queue if you're willing to pay money. But in general, it takes usually 3 years, sometimes longer, to get a patent through. And in other jurisdictions, it can be even longer. Canada it can be pretty slow. There are schemes and mechanisms in place, depending on the route you take with your patent, that can kind of push the prosecution forward, and it doesn't cost as much. But it all really depends on how urgent it is for you to have what we call an issued patent. So what we just saw there, that beautiful booklet that Dan has, is it's all about that, right? If that's really critical to your investors or your business, then you can take steps to kind of push the process forward. But it usually takes a couple of years.
I guess for me, I was so specialized. There's not probably too many wheelchair accessory inventions coming along compared to like an app, something like that, right?
Well, exactly, and we're finding that the mechanical area is particularly fast in comparison to the software, AI area, business methodology. That area is so swamped with applications. It's slowed a bit, but I mean, like I said, the U.S. during COVID in particular did a superb job at keeping things going. They really have done a lot of remote work already, and they were set up. So I think compared to some other patent offices, they were well prepared, and we didn't really see a change in response times or anything like that. In fact, in some cases, it's picked up. So it's pretty impressive.
Wow. So for an entrepreneur who's like, if this is their big thing, and this is where they're banking all their bucks, they may be sitting in limbo for quite a while, essentially not really doing a whole lot with their business until that is established. Am I right on that?
Well, no, actually, they can do a lot more. I mean, as soon as you've got your filing date, as Dan indicated, there's that sense of relief that it's a first to file system. So it's the first person who gets the idea, so to speak, to the patent office. You're in your queue and you get your filing date. Once you've got your filing date, you're free to disclose. You really need to make sure that you keep your idea secret until you've got something filed somewhere, because it is a first to file system. So, there's some exceptions to that. There's some grace periods that if you have, let's say you're going to a trade show, or, you're presenting a paper or something like that, there is a bit of a grace period, but we really tell clients all the time, please, come to us, we'll file something. There are mechanisms such as a US provisional patent that allows you to file and get a filing date, and you're free to disclose whatever you have in that document. And so you really want to, get that patent pending, and you'll see that probably a lot on marked products that you've purchased, or things, devices that you have in your house. And what that means is that somebody has a patent filed somewhere in the world, and in the midst of prosecuting that patent, so the 2 years or 3 years or 4 years or however long it's going to take. And so you can market with that. In fact, and you asked earlier about when is it appropriate to file a patent. It does depend as well when it is, and we can talk about that. But, for some clients, all they really care about is having that patent pending status that allows them to go out and get investment It allows them to show that they're moving the business forward. It shows that they're making an attempt to have a monopoly or something that's exclusive to them. Exclusivity is important for a lot of investors, so as to stop, somebody down the street from doing the exact same thing and therefore having to compete on price or whatever. So from that perspective, I think it's, companies should not be at a standstill during the prosecution process. They should be aggressively going and making sure their market is what they think it is, because during that prosecution time, your claims, which are really these sort of, I'm going to say the monopolies, they're descriptors of the monopoly you're hoping to get at the end of the patent. Usually you'll see them, they're all numbered. Those claims really can change as long as they're supported by the description. The scope of the claims can change during the prosecution. So as you start to work your invention, market your ideas, and get out there and see what your feedback, if that is your first opportunity to do so, you might find that the commercialization offering shifts and it's maybe a little bit over here, whereas your claims are over here. During the prosecution, you're then able to shift the claim language, hopefully, to capture what it is you're actually commercializing. So as a result of that, it's a great time to be out marketing and working your invention hard and getting feedback, making sure, using Dan's invention, making sure that everything's all working and production and everything is happening the way we wanted it to, the way we thought it would. It all depends on at what stage you filed the patent and how that sort of matches up with your business.
Agree. And Lorelei, I guess another thing too would be if because you say it takes sometimes 4 to 5 years to get a patent issued, and sometimes patents don't get issued, right?
Well, that's true.
You can sell within those 4 or 5 years, and you can actually make your business something, right? Yeah. I don't know if you want to touch up on that, or do you have any?
No, I think you're exactly it. Like, it's typically unusual. So when you're drafting a patent, you want to draft a nice big broad monopoly so that it lasts the 20 years, so that it has those legs to carry the business through, from this iteration to the next iteration if you're not doing subsequent filings. So you want it to have some breadth. But typically what happens when we draft, if we draft super broad, we're going to hit other people's patents who've already got protection that's out there. That's the prior art. So we have to wordsmith and bring the monopoly in different points. So if you think about that, if you get a lot of objection or concern and you start to really bring the patent in tighter and tighter, your monopoly is getting smaller and smaller. So your exclusivity is getting smaller and smaller. And as a result of that, some people are like, well, then what's the value of it? If it's this small, that's not really going to allow me to build a business, right? That's not really something I can build a business on. And once again, it depends on the subject matter, because some clients are like, even that small advantage represents huge dollars, right? But for some people, that small advantage doesn't, and that's where you have to have that good dialogue with your lawyer or your agent, and you really understand what it is you're getting at the end of the day. Because there's nothing worse than saying, getting a patent at the end of the day, and you've narrowed it down because you've had to, but it has no commercial viability for you, right? So that's where sometimes you abandon the patent intentionally, and you say, you know what, I'm done. The scope of the claims are so narrow. It's not what I wanted. My business is over here now. Or maybe you didn't do a patent search at the beginning, and a lot of clients don't these days. They just run with it. And there's lots of reasons why, and we can chat about that as well. But it really has to be in step with the business plan.
Yeah, absolutely.
Wow. There's so much to consider with regards to patents and the whole 9 yard. Now, so when you're applying for a patent, right? There's an application process and there's a background search that happens. Can you tell me a little bit about what that is?
Sure. Dan alluded to, because you went through that, and I think what's important to think about is patentability searches really look at this is your invention. So we usually do an intake with a client to understand what the invention is. And inventions are all classified according to international or US classification systems. And they've all been categorized. So all the patents that have come before you, all the pending applications, they're put into classifications, and that's how they're searched. Okay, so I want a monopoly for X. I'm going to go search in class X to see, what do the other patents look like? How close are they to mine? And that's what a patentability search does. There are other types of searches that we can chat about, but basically it gives you an idea of is there enough there, or to basically meet those three tests of utility, novelty, and non-obviousness. And so there's an actual searching part that's usually done by a third-party provider, or some people do it themselves using Google Patents or whatever. And there's pros and cons to that, because there's different types of searching. There's classification searching versus word searching. So let's say I was searching the wheelchair concept of Dan's, what would I put in to search for that to see if there's other stuff? It's much more accurate if you do classification searching, because what I call something and what you call something, Nicole, could be two different things. And yet there might be a patent out there using different terminology, but really having the same scope of invention, which then could later on be prior art to what you're trying to do. So the search, though, everybody has a different thought about it. Some clients are in such a rush, they decide they're just going to file right away and get something filed. And that could be because, once again, they want to look good for investment, or because they're going to disclose and they want to make sure they have something. And they're going to do, I've had clients who do the search after filing something because there was a timing issue and they really wanted to do that. But the patent search sort of gives you a preview of what you can expect. There are mechanisms now in place too that I think are not taken advantage of, that actually help you, and there's sort of real life situations. And that's where you file a patent in a foreign jurisdiction like the UK or Sweden, where they actually, within that first year, and we can talk about what happens in that first year, you actually get a search done by a professional patent office. And what I mean by that, by a government body that's very experienced, and they do the search. And that gives you a real preview of what you could expect from other patent offices, because searching is subjective, right? It is somebody typically doing it. Like I said, there is a judgment call. So it's never an exact science, but there are ways of now doing it where you're actually maybe, I think in some ways it's a bit more, I'll say exact, to go and do this idea where you file sort of a test application, see what some of these patent offices really think about it. So in a real life situation, what kind of prior art can I expect? And that would give you almost the same idea as the results of a patentability search. But both are options. But like I said, you may choose not to. It's an added cost. The cost can vary. And so once again, when you're building your budget, that's something you should be discussing with your lawyer or agent to decide if it's appropriate for you.
Okay, perfect. So let's move into international patents beyond the US, because I know technically the US is international, but they're so close.
And they're very popular.
There is international. I mean, we can walk there from here, pretty much. But beyond that. So you brought up the UK, but there's China, there's Korea, there's a ton of other countries, in case nobody knows. And just wondering, international patents, go.
All right. So if you decide, I'll just take one step back and talk about the process of filing, because I think if we start at that stage, whether or not you do an international patent, and we can get down to the nitty gritty of what that is. So typically most people want to get something filed quickly for the reasons I've sort of alluded to before. That can be in the form of what we call maybe a regular patent, and you might file in Canada or the US. Once again, it's usually typically the US, or it might be something called a provisional patent, a US provisional patent, which gives you this 1 year. So regardless of what you start with, you have this 1 year from your earliest filing date in which to file what's called an international patent, or PCT, or Patent Cooperation Treaty. This mechanism has been really great. It's been around for a long time. because it allows you basically to use one app, your one single filing. So think about that. You've already drafted your first application. Maybe during that 1 year, you've had some additions or addendums and you want to, change a few things. You can do that within your 1 year. And then when you file your PCT, you basically just tick off, it covers all the countries in the world that are members, which I think are now, God, well over 130, I'm sure, if not more. I off the top of my head, I can't remember now. But all of that to say, huge savings, right? Because in the past, you would, before the PCT was around, you'd have to go and file individually in all those countries, which was really ridiculous, right? Nobody could afford it except pharmaceutical companies or large, petroleum companies, things like that. So the PCT allowed access to intellectual property rights globally, and you pay a Canadian government fee that's sort of coming at around $4,000. So it isn't an insignificant amount, but when you think about all the countries it covers in the world, it's actually a pretty good deal. So yeah, I mean, think about it. It's really good. You still have your legals. Let's be clear. You'll have your legals, but the government fee alone is really quite fair. And what happens is it basically buys you. So the way you kind of have to think about it is it buys you another year and a half in which to have to make any really serious decisions as to what other jurisdictions you want to go to. So, and why is that important? Well, because when we get back to, young scaling companies, you may not know where your business is going right off the bat. And to have to make those expensive decisions right off the get-go is really not fair, and I think prejudicial. So that's partially why this system has flourished so well, is because it gives people lots of options. It keeps sort of the dream alive globally for another year or so, right? So from all of that to say, what typically happens is you file your first application, or some clients start right off the bat with a PCT, which gives them a full 2.5 years. But most people do a first filing, then file at the 1 year mark, but you can file at any time in between. And your PCT starts the last possible day you can file it as on your 1 year anniversary. And it's important to think about that, because once again, dialogue with your patent lawyer and agent to make sure you file when you need to file. All those good things have to happen. And then it basically, you get a great search report. So we were talking about searching authorities, and whether it's UK, Sweden, US, or whoever, you want to, they'll give you an idea of what art they found with regards to your invention. So coming back, it ties into the patentability search. If you've done a search and let's say there's 3 things that you found, or 3 other patents you found, and they're sort of close, but we think we can get around them either by wordsmithing, or we feel that with explanation we can dismiss those patents, and your search report comes back, and sure enough, there are those 3 pieces of prior art. Then that was a pretty good report. That was a pretty good search. It was pretty accurate. And you know what to expect, and your arguments are ready. And during that 18 months, while it sits with the international authority, you can actually dialogue with them, amend claims if you want to, or you can choose to do nothing. So some clients just use the PCT as a way of extending, once again, their global options for another 18 months, in which they're, busily working on the business, figuring out what jurisdictions that are critical to them. And then on that final 30-month date, and that's 30 months from the earliest filing date, you have to go national. You'll have heard that, I'm sure, Dan. And when you go national, you then actually have to make the hard decision of, okay, am I going to Europe? Am I going to China? Am I going to Australia? But hopefully, you've been on a 2.5-year journey from your initial filing. You have a really good understanding of where your markets are, because patents are jurisdictional. To assert that monopoly, you have to have a patent in that jurisdiction. So usually at that point, that's when the real money hits, because depending on what countries you want to go to, you might have to have translations, right? We're not all in English-speaking countries, so you might have to have translations. Translations, depending on the size of the patent, can be very expensive. If you've got a short patent, that's great. But if you don't, it can be expensive. And you have to file then more government fees at the time you go national as well. And typically you have to file, there'll be legals associated, because there isn't an agency or a law firm in the world that has, offices or patent offices in every single country in the world. So you're going to have some additional legals outside of your own legals that you're having here in Canada. You're going to have foreign government fees. And then we have, all the prosecution that's going on. So if you pick 5 countries, you're going to have 5 different prosecutions going on. The goal of why you typically start someplace like the US is to minimize those costs once you get to the national phase. So the goal is to get what Dan just showed is that beautiful patent, right? And to have all the kinks worked out of it, so to speak. And then you basically do what's called the voluntary amendment, or amend the claims to look like your US claims, assuming you like those claims and those claims speak to you for those jurisdictions. So sometimes, and there's nuances in jurisdictions. It's not like all the patent offices in different countries follow the US, but it is an indicator. They have a very robust examination process. So when you go through the US and you get a US patent, it's typically a patent that is looked at by other examiners. So if you went to Australia, the Australian examination team, or the Canadians, are often looking at the US to see what art did they find, what rejections did they make, that kind of thing. So it does sort of knit together. It's certainly not a rubber stamping. I don't want to give anyone the impression that once you get it one place, you can get it everywhere else, but it's an indication. Let's put it that way.
So to go on that point, you said from the date that the patent was actually, you have 1 year to file a PCT.
Right. PCT,
okay.
yeah.
Yeah, okay. And then there's no European Union option available that you can cluster countries together, or
yeah. No, you can. So for instance, there are 2 in Africa, and there's the European one. That really happens at the national phase, where you would the PCT still covers everybody, but it's not like we have like a North American system or anything like that. Okay. So yeah. Unfortunately, but the idea is there's still jurisdictional nuances. That's what I would say. And there's some areas, some subject matter areas in particular, that certain jurisdictions definitely don't have the same rules, and they don't apply the same rules. But like in straight mechanical stuff, it's pretty consistent. So you can kind of get a good idea of what's going to happen in other jurisdictions based on what happens in the US. So, and that's why I would say with patents, it's not really, I hate to say it, a one size fits all approach. There really is a bespoke approach to most people's inventions. And if you think about it, everything's so unique, right? Like everybody's doing their own thing. Yeah. It's their own baby, their own dream, so to speak. So you can't just assume that, okay, I'm going to apply this strategy for this and it's going to work. You really have to have a dialogue or discussion and with your patent lawyers to make sure that they understand what your expectations are, right? That they understand what you're looking to get out of this, to make sure that it's cost efficient for you and your expectations are managed. Let me put it that way.
Exactly. I mean, I know the firm we use at the start gave us a couple of those tips and tricks, and one of them was to say, hey, make sure you pass examination first in the US before you enter examination in Canada. Because once you make all those amendments to your patent and you're ready to go with it, then you can access examination in Canada, and they're most likely going to be okay with everything that the US did.
Yeah, and that's exactly it. That's why when you go to a place like the US, which have, this is not just a plug for the US, but they do have a large number of examiners, right? They're a very robust system. Mm-hmm. It is, I still think, the largest depository, though I'm not sure about that anymore, of patents in the world, because everybody wants to go there. It's a huge market. So they see a lot of different inventions in a lot of different areas. So they probably have the most experience. You're still going to run into examiners who, are going so fast they didn't read or they didn't understand your invention. And that's where they're great about picking up the phone. You can call them, you can talk to them. They're excellent. Back in the good old days when we could do this, you could actually meet them in person, and clients would sometimes come with you, and you could go and speak to them in person, and really, and show them what's new and novel and different about your invention and why it deserves the protection you're seeking. So all of that to say, it's a little bit different now in COVID. But we've done video calls with examiners, everything else to try and make sure that they understand the invention. You have to appreciate they're seeing so many different inventions every day. Like, it must be mind blowing. It's a constant change, right? So whereas you are the best, you're the inventor, your invention best, right? You're passionate about it, the ins and outs of it, all of that good stuff. So that's what we want to present to the examiner and help them understand. A patent should always read like a story. It should tell the story of where it comes from, which you'll see in the background of the patent. It should tell where you're going and where you've ended up, and all the details. So it's enabling. You might have heard that terminology. It's enabling for everybody. So the goal is, at the end of that 20-year, anybody should be able to pick up that document you have and read it and be able to recreate your invention from the figures and the description and practice it. So that's the ultimate goal, so to speak.
Perfect.
Fantastic. Wow, that's great. This has all been such great stuff.
Yeah, I mean, I'm even learning more. It feels like we need to have a couple more follow-up conversations.
That's great. So our time is moving forward, but before we end, I was wondering, from both of you, really, tips and tricks with regards to the whole process. Tips and tricks to save money, or looking for the right lawyer, anything, filing and maintaining the IP, all of that. So tips and tricks, 5 tips and tricks.
I'll just say one of mine for sure is really communicate a lot with your legal team, so that things don't happen like abandonment, right? No, and it happens because like I said, like Lorelei said, people, these legal teams are getting so many patents all the time. I think they might miss an email or something like that. So just make sure you're involved in the process. Just don't hand it off and hope for the best. Just make sure that you're talking with them, you're checking up with them, and they're checking up with you, and just communication is the best. And it helps you to align your timeline according to what you want your business to, and how you want your business to grow. So that's one of the main tips I can definitely give.
Yeah, I think the biggest thing working with scaling companies, and whether you're a startup, a scale up, a SME, whatever, even if you're a multinational, really make sure you have a business plan for this product or this invention, and match the IP strategy to it. So time and time again, we see people going off down a path, and the paths are not meeting. They're not even in the same ballpark. They have to really be together, because why does that matter? Because if we go and we patent something that's totally irrelevant, everyone's going to be irritated, right? And I'm a proactive, I'm not a big fan of litigation, and I'm a proactive person to reduce irritation. Yeah. So I really think that make sure your lawyer or agent really is listening and understanding what the business proposition is for this patent. To Dan's point, he's alluded to this a couple of times, is like, we really do have to have a budget, and the budget has to be realistic. And what I mean by that, this isn't, if you're looking only to spend a couple $1,000s, then the patenting side is really not for you. It isn't as atrocious as people think. Think about this. If you take a patent and you amortize the costs over 20 years, does that make sense? And usually if you're going to be commercializing and selling, it does. But realistic budgets are really important. And I think if you get to a scale in your business where you can do it, is to have this, leads into Dan's point about communication, one point of contact to make sure, or at least a person who's designated in the business who's going to be dealing with the lawyers, because it is a time suck, for you to take away from your business duties and to deal with that. But you can actually reduce legal costs by providing really good quality descriptions of what your invention is, to really doing your due diligence and understanding the patent system. But by all means, ask questions. There are no questions that are stupid or whatever. If you think you don't know, you should know the answer. Always ask questions. Get things in writing. I also encourage people to get things in writing and quotes. This is a area of law where there are some certainties. There's not a lot of certainty in anything, but there are some certainties here, especially around government fees and things like that, filing fees, stuff like that. So I do think if you can do that, that'll help manage people, the communications, and people, to the example of the abandonment, making sure somebody's following up so that your times when you should expect something from the patent office and why didn't we get it or whatever. And you can go on now in most databases and check the status of your patent yourself. So if you have somebody designated internally to do that, they can check just as a backstop, because no system is perfect. And whether it's a law firm or the patent office actions do get lost in electronic mail systems. And that's just the way it is. The only other tip I would encourage people to do, and it also depends on the size of your business, but is to educate people. The more education you have about the topic, the better. And the reason why I bring that up is because, we've talked really about one invention, but really if you have a team of people, there should be next iterations and the next generation of your invention. Rarely does an invention stay stagnant for 20 years. So you want your people to understand the patent process so that they identify those next iterations and next generations. And the advantage of that is that then they can say to themselves, okay, well, wait a minute, I better go, speak with Joe, who's our appointed person, to make sure I'm not disclosing something that's potentially patentable and could be valuable to the company. So you're protecting your assets that way. And it may be in the end, there's nothing there, and that's fine. But it might be that there is something there. And you want to make sure that you are accruing all that intellectual property knowledge back to the company and the assets back to the company, and not just pushing it out into the world. As much as the world is a great place, we want you to monetize what you can monetize. So I do encourage people to educate, and it's really easy to do. There's lots of great programs, and I think that really helps companies stay afloat. And finally, I think it's always good to think about your IP sort of pathway as almost like when you're redoing your business strategy, or you're checking in with your strategy and goals, to check in with the IP strategy at the same time, making sure it's marching along in step. Because if you have departures in personnel, or things are shifting or changing, or you have a new investor, things might be getting off and a bit off track. And you can use those opportunities, twice a year at a minimum, to kind of make sure everything's kind of copacetic and going forward in the right way.
Well, fantastic. Well, thank you so much for that. And I want to thank both of you for joining me today. Now, if people want to learn a little bit more about patents and IPs, where would they find that kind of information?
Well, for me, I think the Canadian Intellectual Property Office and the USPTO, the U.S. Patent and Trademark Office, do great jobs. There's lots of great videos on the USPTO website to help entrepreneurs get started in the patenting side of things, and not just on patents, but trademarks, industrial designs, or design patents. Because once again, it may be that this isn't the right, methodology for you, and you want to pick some other mode of protecting your ideas. So I think the governments do a really good job at educating, and there are a lot of great law firms who have great websites explaining exactly, what's latest and greatest, or some basic 101s. There's also great in Ontario, all the different RIC centers, though I know some of them are doing different things or have different focuses, but the RIC centers that basically have all of that information there as well. So, and podcasts like this.
Well, thank you so much. And again, thank you both for your time. Dan, if anybody wants to learn anything about your invention and what you're all about, where would they find that?
Yep, they can check us out at www.bisep.org. That's a BISEP.org, or our socials. It's at BicepCo, BISEPCO.
Fantastic. Well, again, thank you guys so much. Now, to our listeners, you're going to want to stay tuned for our next episode, where we're going to be talking to some of our local entrepreneurs in the tourism industry. We're going to talk about tourism in Niagara and, the impact that this crazy time has had, and kind of stuff to look forward to moving towards the summer, which, they keep telling us we're supposed to have a better summer. So, hey, let's hope. Why not, right? So thank you again, Dan and Lorelei, for your time and your expertise. And thank you again, listeners. And until next time, this is Nicole signing off.
Thank you for joining us on SparkCast. If you want to know more about Spark Innovation Educational Center and how we can support you, visit our website at sparkniagara.com. See you next time.